So good morning, everyone. Welcome to the Appellate Division First Department. Oral arguments for today, November 8th. So as you know, the spiel, please only ask for the time that you actually need in order to get out the salient points of your arguments. Please keep in mind we have read your briefs. We are fully familiar with your arguments. If your time runs out and the panel has additional questions, we will certainly put them to you. People v. Anthony Griffin. You're requesting 4? 4, 1, and 4. Coalition for Fairness of the City of New York. 6 and 2 and 6. Matter of AM Children is submitted. Federation of Organizations versus Lindsay.
Morning. Division of 5 and 2.
For the appellant, 5 and 1.
5 and 2, 5 and 1. Wildfur versus American Board of Pediatrics. That matter is submitted. Scott v. New York City Department of Correction. That matter is submitted. People v. Justin Parker. That matter is submitted. Atalia Special v. Sustainable Opportunities.
Appellant, 7 and 2.
7, Your Honor.
6, 2, and 6. Trotman v. Precision Elevator.
Appellant 5 and 1.
Which responded to you? Precision. And how much were you requesting? I'm sorry.
The second respondent both times.
So you're submitting?
Yes.
Okay. 5 and 1 and 5 in a submission. Matter of Our Children is submitted. Valkyrie AI versus Price Waterhouse Coopers.
For appellant, 8 and 2. Respondent appellant, 4 and 2.
Which responded to you?
I'm sorry. I am respondent Valkyrie, and I'm also counter appellant.
And how much time were you requesting?
4 and 2, please.
For respondent, Sagents, and Moravia,
6 and 2, 4 and 2, and 5. DeMartini v. Sewell. That is submitted. Mostock versus Hebrew Home for the Aged.
For appellant, 4 and 1, Your Honor. For respondent, 5, Your Honor.
4, 1, and 4. Marshall v. City of New York.
For appellant, 5 and 2.
3 and 1 and 3. People v. Phyllis Hubbard. That matter is submitted. People of the State of New York versus the National Rifle Association. That matter is submitted. Hessler v. Advanced Dermatology. That matter is submitted. We are honored today to have the students from Ness plus M. High school students are here, and they're over seated to my right. They are accompanied by Mr. Benjamin Waldman and Ms. Janet Perlberg. So these are high school students who are actually contemplating becoming lawyers. So, lawyers, I know, right? No, don't do it, don't do it. But, you know, this is their dream, this is what they want to do. So, lawyers, be on your best behavior today. First case for argument, People v. Anthony Griffin. Yes, you may proceed.
Good afternoon. My name is John Palmer, appearing on behalf of Anthony Griffith. Mr. Griffith's lifelong battle with addiction and substance abuse precipitated this serious offense. Today, however, Mr. Griffith has the insight, support, and motivation to maintain his sobriety in a safe, therapeutic setting, and we ask the court to reduce Mr. Griffith's sentence to facilitate this treatment without unnecessary
So
delay.
this case involved a carjacking, is that correct?
Yes, that's correct, Your Honor.
And I don't know, unfortunately, it was a carjacking of an off-duty police officer.
Correct, Your Honor.
But the children, or at least one child, was in the vehicle at the time that Mr. Griffin attempted to make off with the car, is that correct?
Yes, that is correct, Your Honor. A child was in the car, and
And
fortunately...
this was also Mr. Griffin's second carjacking. He had a prior carjacking as well, did he not?
That is correct, Your Honor.
And so, again, he received 10 years incarceration, is that correct?
Correct, Your Honor.
And you are requesting what?
We would request a 7 years, Your
A
Honor.
7-year sentence. At the time of his initial, one of the initial meetings with the judge, I believe the people offered, I don't see what the people, they offered 12 or something like that, and he said he would take 10.
Yes, that was at the time of the initial plea when Mr. Griffith believed that he was facing sentencing as a second violent felony offender with the risk of sentencing as a persistent violent felony offender. And of course, we know that that is not true. But Mr. Griffith acknowledges that his battles with addiction and mental health have motivated his offending.
And was this information known to the court at the time of sentencing?
Yes, Your Honor, this information was before the court, and yet the court still refused to consider a sentence below 10 years.
Well, the court
despite-
considered, and based upon its consideration, determined that that was not the appropriate sentence. So what then has changed from the sentence to today?
From the time of the initial sentencing
Yes.
to today, Your Honor, since Mr. Griffith's 2017 arrest, he has changed his thinking and gained an understanding of how both his addiction and failure to address it over the course of his
This
lifetime.
particular time period that you're talking about, has he been incarcerated?
Yes, for the entire time, Your Honor. 7 years will be tomorrow from the date of the offense. And over that time, Mr. Griffith has consistently demonstrated remorse for his actions to courts, his family, and program staff. Not only that, he's expressed a strong motivation to maintain his sobriety and enter inpatient
While
treatment.
incarcerated,
Yes, while
maintaining his
incarcerated.
sobriety while
Well,
incarcerated.
maintaining his sobriety going forward throughout the rest of his life.
I
Mr.
see.
Griffith's program participation over the past 7 years evinces.
I guess the point that maybe we're trying to get at is that prior to this incident, he had been in treatment, and then he left that, he was dismissed from that program. And so now, since 2017, this period of reflection has all been while he's been incarcerated. What is there that's different, other than the fact that he's been in this confined setting, and now he's had time to reflect, but when he was out, that didn't exist?
Well, Your Honor, of course, Mr. Griffith had failed treatment in the past, but most treatment admissions result in relapse. This is not unique or unusual to Mr. Griffith. And I think
That
the
is, in
upshot-
fact, true, but maybe sometimes they don't result in the facts that led us here today.
That is true, Your Honor, but the upshot here, a reduction in Mr. Griffith's sentence, of course, will not grant him any windfall. He's already served 7 years in this case.
Counsel, Mr. Griffin was originally sentenced to 12 years,
Correct.
and then he was brought back for resentencing.
Yes,
And it was at the resentencing that he received the 10 years.
correct.
And all of this information that you're providing the court now was available to the resentencing judge at the time.
Yes, Your
And
Honor.
the judge decided that I'm not going to give you less than 10 years if you want to take it down. Or you can go to trial.
Wherein he would receive, what was it, 15? So is the minimum 15?
The maximum was 15.
Maximum-
The
the
minimum
maximum
was
is
3.5, Your Honor.
Thank you. You have time on rebuttal.
Good morning. May it please the court, Catherine Murata for the people. Defendant's sentence was fair and appropriate and should not be disturbed on appeal. All the factors that defendant references were already well known to the resentencing court, and Justice Kiesel took them into account when fashioning defendant's sentence. In fact, the court imposed a sentence 2 years less than what the people had recommended. Furthermore, given defendant's criminal history and the seriousness of this offense, defendant's prison term is warranted. Defendant had a criminal history that spanned over 40 years, many of which included violent offenses, including a first-degree robbery, a carjacking.
But, counsel, I mean, we can agree that people with drug addictions tend to relapse, and sometimes the decisions are not necessarily the best once they are in that relapse. And so now, Mr. Griffith has had the opportunity to reflect on those issues, and he's participated in programs, he's sought, the requisite treatment. Why wouldn't we exercise our discretion in that kind of situation? Or why shouldn't we, rather?
I think it's important to note that, he's having these strides while he's incarcerated, but several times he's exhibited while he's, in the community, he's incapable, as the probation noted, he's incapable of functioning in the community. and a more restrictive setting is appropriate for him because
Well, if we agree that incarceration, that one of the aspects of incarceration should also be rehabilitation, why should we not then say, well, you know what? He has been rehabilitated to some extent in that he recognizes what he must do once released to the community.
I think all of these factors were already known to resentencing court, his attempts at rehabilitation, and the court fashioned a sentence that kind of struck a balance between these mitigating factors and an appropriate sentence. Several times he committed offenses and while out or served his time in the community committed more offenses. So I think his previous behavior has exhibited that he is incapable of not committing more crimes. And there also, tend to be violent offenses. He's had a criminal history over 40 years. And I would note that he was in drug treatment while he committed this instant offense, but hijacked the car with a child inside, attacked an off-duty police officer, and crashed the car into several parked cars. So I think given the criminal history and the seriousness of this offense, the 10-year prison term was warranted.
Thank you.
Thank you.
Just have 3 quick points, Your Honors. The prosecution has mentioned that the pre-sentence report said that Mr. Griffith's service needs should be addressed in a restrictive setting. Yes, that's true. Mr. Griffith has already served 7 years in prison to this date and only seeks release to an inpatient treatment program. And a good question to ask ourselves is, why does treatment matter now after he has been in for 7 years? But it's commonly accepted in the criminal justice community, and given Mr. Griffith's history and the history of many men and women who come before this court, that treatment and incarceration is not a valid, effective alternative to treatment for this chronic, recurring disease of addiction. And a reduction in Mr. Griffith's sentence would simply allow him to enter treatment immediately. And our office is prepared to help place Mr. Griffith in a suitable inpatient treatment program, and whenever he is released, he will have to satisfy a 5-year PRS term that will provide additional support, programming, and stability. And for all of those reasons, and those cited in our brief, this court should reduce Mr. Griffith's sentence to allow him to continue his road to recovery and receive the treatment he needs. Thank you.
Thank you. Thank you both. Coalition for Fairness v. City of New York. Yes, you may proceed.
Good morning, Your Honors. On behalf of the appellants, this case challenges the constitutionality of an unprecedented land use exaction fee for the issuance of a permit. The paradigm in this case violates both the entire jurisprudence of Nolan, Dolan,
Counsel,
and Kuntz.
could the city impose a fee for if the money were to go to housing for artists?
Well, there may have been an opportunity in that situation to establish a nexus,
That would be a nexus, right?
which would be a purpose, but the fee here is not going to housing. The city was very explicit in saying this was for the cultural enhancement of cultural projects, artist projects below 14th Street.
Is there any way to, I guess, extend the fact that this particular housing affects artists? This is an art fund, and therefore there is some nexus, or is that too loose? Is that too tenuous?
Well, I think for that question, you have to look at the historical implications of the JLWQA legislation, which was both in MDL 275 and MDL 280, which was to create housing for artists. And it was to legalize manufacturing use so that artists can live there. This fund,
It wasn't just that they would live there, it was also that they would work there. So it was to
Work there,
encourage
yeah.
also, wasn't it, the work of artists, not just that, to give them a place to live?
correct, correct. But at its base, it was to provide them with safe and legalized housing that they could also work there. Now, this fund, and if you look at the Nolan case, which talks about nexus, this fund goes to a very broad, well, first of all, broad geographic area, everything below 14th Street. But then the purpose of the fund is for cultural enhancement. So then you have to look at what is the societal problems caused by converting from artists to residential use, which, by the way, the statute encourages. So you have a contradiction in public policy. You have the city passed a law which says after 2021, you can no longer convert to JLWQA. But what we're going to do is punish those people who seek to follow the statute. You're going to follow the statute, they're going to convert to residential, and you're going to have to pay for something we, the city, did in contrary policy.
But does it matter that the payment could be pushed over to the sale of the property?
Well, you know, it's interesting because the city did an analysis which is totally in opposite or contradictory to the whole Nolan-Dolan framework. The city said, well, because conversions will increase profits, we can take those profits and use it for cultural enhancement for an area maybe 10, 50, 100 times greater than the area of Soho, NoHo to improve the cultural legacy of artists. So the first question is, why did the city pass a law which prohibited JLWQA use in the future? If the public policy was to enhance cultural artist amenities, why prohibit JLWQA
Well, isn't
use in
that
the
the
future?
easy answer to that question, that artists can't afford Soho anymore? I mean,
Right. So artists can't afford it. So you look at Nolan, Dolan, the whole framework. Is it the fact that people are converting from JLWQA use to residential use, which the statute compels? Is that causing a societal detriment to the cultural legacy of artists? If the city was interested in enhancing the cultural legacy, why would they prohibit JLWQA use in the future?
Well, is it that the artists are now making a profit by converting the space that they were supposed to have as a joint living work space, that they're now making a substantial profit by converting and then selling to others?
They may be making a profit, and
A considerable profit, right?
perhaps we don't question that study. But if you look at the analysis under Nolan and Dolan, the question is not whether someone enhances the value of their profit, but whether they have done something that opposes public policy, and therefore they have to pay for the detriment they've caused to public policy. And there's nothing here in this analysis. City's done no study to determine, well, if I convert to residential use, how is that a societal burden on the cultural amenities for artists south of 14th Street? There's been no analysis of what that connection is. If I convert to residential use, am I taking away from artists' museums? Am I taking away from the enhancement of cultural amenities south of this huge geographic region, which is multiple times larger than this small Soho, NoHo community? You're putting the burden on a few hundred families to do something to ameliorate something they didn't cause, something that they're doing to adhere to 143-13 of the zoning resolution, which requires that in the future, all units must be residential because they banned JLWQ use. It's contradictory, it's illogical.
And you have time on rebuttal.
I'm sorry.
You have time on rebuttal.
Oh, I have time, so I guess I've concluded now.
Yes.
Okay, thank you.
Good morning, Your Honors. May it please the court, John Shep Wong on behalf of respondents. I think I'd like to first emphasize that there is a threshold step here that my colleague has kind of moved past, and that is the initial hurdle that of the unconstitutional conditions analysis is that you have to analyze the burden that is being asked of these folks for the permit outside of the permitting condition, outside of the permitting context, and determine whether it is unconstitutional on its own if it were applied outside of the permitting context. What the city is asking for here is a simple fee, and I think case law is very clear that
Thank you for bringing up case law, because I would love for you to talk about this simple fee in the context of the Supreme Court Sheets case.
Sure. So in Sheets, the court didn't reach this issue at all. So in Sheets, the only question that the court was addressing was this legislative versus adjudicative distinction between fees that are imposed and whether there's a categorical exemption for fees that are imposed through the legislative process. Sheets said no, but they left it open entirely whether the fee in that case even was subject to Nolan, Dolan, or Kuntz and the essential nexus and rough proportionality analysis.
But it did discuss that Nolan-Dolan test, and it did reaffirm underneath that text what exactly needs to be an essential nexus and what needs to be rough proportionality. How is that shown in this particular case?
Right.
Sure.
So what is the essential nexus to the government's land use interest here?
Sure. So assuming that this is an unconstitutional issue and that triggers Nolan and Dolan, the essential nexus here, if we look at exactly why the JLWQA provisions existed, there is a match between that purpose and the requirement of the fee here for the Arts Fund. And I would point this court to MDL 275, which explicitly states—
Well, how do we get to the Arts Fund as opposed to, how do we get to the Arts Fund? Why are these monies now going to the Arts Fund?
So I think that it's important to remember that JLWQA is not just a artist residency restriction. It is a joint live work. Work is important here as well because it advances the artistic capacity of the city. It enabled artists to perform their art in the city. And that is exactly what the Arts Fund fee is also doing here by enhancing the cultural capacity of the city, enhancing the city's cultural legacy, and that was a focus—
Does it not have to have some sort of relation to their housing?
No, Your Honor, I don't think it does because, and I would point Your Honors to the Court of Appeals case law, which is fully, it has not been affected at all by Kuntz or Sheets. It is fully a binding precedent to this date, and we look at Consumers Union. It asks, is there a consistent purpose between the restriction and the condition? Is there
Arts Fund just, and you can put your spin on it, but it seems that it's something that benefits more so the public, and that is a burden that shouldn't necessarily be passed along on these individuals, and that's particularly why that Nolan-Dolan test needs to be analyzed.
Well, there's a public benefit for the JLWQA as well. It wasn't just about these individual artists and their ability to live in Soho and NoHo. It was also about enhancing the city's cultural life, and that's very clear from MDL 275. It's explicit that that was one of the primary purposes of having this joint live work restriction. So that's why enhancing artist capacity and having this grant program serves the same purpose as JLWQA.
Why JLWQA also, why was it housing as well as work? Why then, under your analysis, why would it not have just been work? Why did you need the housing component of it?
Because it recognized the unique circumstances of Soho and NoHo, the historic reason for this manufacturing district. So it was all about work in Soho and NoHo. And as manufacturing decreased in the decades in the 60s, I believe it was, those spaces were taken over by artists. So it was taken over by artists not just for residency purposes, but also for work purposes. And that's why the work that...
Right, and so, but the fund does not recognize that. The fund doesn't recognize the joint living and work space.
It does not recognize it directly, Your Honor. I think that's correct, that it's the
But
grants
doesn't it
are
have
for...
to? Isn't that what we're talking about in terms of the nexus? Doesn't it have to?
I submitted that it doesn't, Your Honor, because of this work aspect. So JLWQA was not just about housing, it was about work as well. And just as a matter of logic, Your Honor, I would submit that, if it is easier to be an artist in the city because of these grant programs, that also has a down the road impact on the ability.
But why are the artists the ones who are now the ones who have to pay for this fund?
Why are
the ones who are contributing to the fund?
Well, I think, Your Honor, it's the point is that this is a wholly voluntary conversion. So I would just emphasize that point as well. That none of these people that live in any of these lofts have to go through this process.
Counsel, isn't it also the case that a number of them are not artists, and they took this particular kind of housing knowing that there was restrictions on the residential use of these buildings, and they took them even though they weren't artists?
You're absolutely right, Your Honor. That is another major point of this particular situation, is that many of them are not artists in these spaces. So this is not harming artists. What it's doing is trying to capture some of the impact that removing this artistic amenity from the city, turning it into fully residential use that doesn't have any artistic restriction any longer, into an occupancy restriction, and trying to ameliorate that impact on the artistic community.
But there's no distinction made between the conversion by those individuals who are fully protected by JLWQA and those who are not. Right?
Well, everyone now in these units has amnesty, so they are all legal residents, occupants of these units.
That was the effect of the 2022 legislation, correct?
That's right. So there were a couple of amnesty provisions. There was one in the mid '80s, and then another at the time of this rezoning. But I think that regardless whether someone is an artist or not, you're still removing an artistic amenity. It's a choice that these individuals are making, whether they're artists or not, to say, okay, this unit no longer is restricted occupancy for artists. So that is a removal, regardless of the status of the current occupant, Your Honor. And I see that my light is up unless there are any other further questions.
Thank you.
Thank you, Your Honors.
Thank you. In answering your question as to the fact that many of these units may have been running afoul of the JLWQA requirement previously, the Nolan-Dolan-Kuntz trilogy makes it very clear that discretionary benefits, so they're seeking a discretionary benefit, these people. They want to convert to residential use, which is now allowable, and it's a discretionary benefit. This discretionary benefit may not be burdened by unconstitutional conditions. That's the key point here, because Kuntz, if you read Kuntz and you really delve into the reasoning, they're talking about coercion. The government, whether it's through administrative diktat...
They use the word extortion, yeah.
Extortion, coercion.
But let me ask you this, counsel. Current square foot costs of these lofts are depressed right now, right? If I was a resident who was not an artist, but I got grandfathered or I got amnesty, and I wanted to sell my apartment and they hadn't passed this legislation, there would be some depression on the per square foot cost caused by the fact that it has a JLQA. You do the acronym better than me. So the city's now the city's lifting that, and so they want to capture some of that profit.
Right.
So your clients will get some of the profit because I think it was a depression of $189 per square foot or something. That's somebody's estimate. So you have to pay 100 of that to the city for arts. You're still doing better than you would if they hadn't lifted the JLQ.
Right, you're doing better, but what Coons, and again, you have to go through that trilogy, Nolan, Dolan, Coons. What they say is the Fifth Amendment is implicated because you're burdening property rights.
Does it matter that it's purely voluntary?
It doesn't matter if it's, because every case that Nolan, Dolan, Kuntz talks about, and there are many, were all discretionary, voluntary. The individual in Kuntz sought to expand his property. And they said, well, if we're going to burden your property, which is a Fifth Amendment implication, then we have to show nexus and rough proportionality. We're not saying the city can't do that. All we're saying is the city did not do that in this case. There was no analysis as to where that money was going. Is it roughly proportional to the $100 per square foot? And is there a connection between the fact that I am converting to residential use, and that is creating a societal burden on cultural amenities, not just in Soho, NoHo, that little area, but in that entire area south of 14th Street. There is no analysis in the record. The City Planning Commission reports, all the public hearings, all of the questions that were raised. There is no analysis connecting either of those principles, nexus or rough proportionality.
Thank you. Thank you both.
Thank you.
Federation of Organizations versus Lindsay.
May it please the court, Adam Markovich, the Bronx Defenders, for respondent appellant Antoine Lindsay. The notice of termination in this case fails to allege any factual or legal basis for the termination of Mr. Lindsay's tenancy. It fails to reference the lease. It fails to reference the prior notice of default. It doesn't state any basis whatsoever for the termination. Instead, it just states that Federation of Organizations for the Mentally Disabled elected to terminate Mr. Lindsay's tenancy. This is insufficient.
It didn't include that there was danger to the staff or the management company?
Respectfully, Your Honor, that is the notice of default. That was the prior notice of default that was served on or about June 27th. The notice of termination, the notice that is required in order to terminate a leasehold, that was served later, and that is a bare bones RPL 232A notice.
In your position is that it must make some reference to whether there was a cure or not, correct? And it did not do that.
That's my position. That's this court's position. The civil term correctly analyzed the case under this court's decision in Tomful. And this court held that if a lease provides that a notice to cure is required, then a subsequent notice of termination has to allege noncompliance with the notice to cure.
Right.
Federation provides supportive housing to some of New York City's most vulnerable tenants. It's subject to the guidelines of the New York State Office of Mental Health.
Mr. Lindsay, is he still, I know this is divorce the record, but is he still in the place?
Yes. The lease between Federation and Mr. Lindsay, a supportive housing tenant, provides that Federation can commence an eviction proceeding in only two circumstances: non-payment of rent or a material breach of the lease.
Well, there was clearly a material breach of the lease here. You have to at least concede that. Attacking other tenants is not allowed under the lease, correct? Or the superintendent?
We have never disputed the fact that the notice of default states a violation of paragraph 6 of the lease, objectionable conduct, but the appellate term was wrong to hold that simply specifying the facts and the legal basis of the landlord's claims, Federation's claims, in only the notice of default was proper. The notice of termination, which is the critical document, says nothing. All of these allegations are absent from it. The notice of termination is exactly the kind of notice that any landlord could serve on any month-to-month tenant in the city of New York simply because they elect to end the tenancy. But the lease does not provide that
But
for
could,
supportive housing tenants.
could Mr. Lindsay have cured his alleged default?
Absolutely.
How?
While the past can't be undone, a tenant certainly can refrain from engaging in objectionable conduct, especially objectionable conduct that's alleged to have occurred only within the space of 1 month.
But didn't he continue to engage in the same objectionable conduct even after he was served with the notice of default and the notice of termination?
The critical period that this court needs to focus on and that the civil court properly focused on is the cure period. You have 30 days to cure between June 27th and...
How do you cure the attempt to kill someone and stating I'm going to kill you? How do you cure that attempt?
You refrain from engaging in that conduct.
But that conduct has already occurred. So it's the conduct that you were attempting to, I mean, it's easy, you don't pay the rent. So you cure that by paying the rent. You can't cure an attempt to kill someone. An apology does not cure it. Not attempting to kill that person in the future does not cure that conduct.
Again,
So I guess the point is that, yes, perhaps you would need an attempt to cure, but if you can't cure it, then
what do you do?
What do you do? It becomes, baseless. I mean, there's nothing you can do.
no court has held that isolated instances of threats, even an assault, are incapable of cure. And in the case of supportive housing tenants who are in housing specifically to provide supportive services, mental health services, perhaps very much could have been done within the cure period. And it's important to note that no alleged misconduct happened in the 30-day cure period.
Thank you.
Also, the notice, I'm sorry,
Go ahead.
notice of default contemplates that there would be a cure, right? So that sort of locks the landlord in, or does it?
It does. A notice of default is not simply a formality. It is a requirement under the lease. It is intended to afford a tenant an opportunity to cure. By the strict terms of the notice of default, the alleged objectionable conduct was cured. No offending behavior is alleged to have occurred in that period. The record shows none.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, I represent the Federation of Organizations for New York Mentally Disabled, Inc. As the Court stated in Jatel v. Coleman, the principles of appellate jurisdiction require that the review be limited to the matters contained in the record. In the civil court and the appellate term, the appellant maintained the consistent argument that the 30-day notice of termination should have contained additional facts that Mr. Lindsay did not cure the violation that was referred to in the 30-day notice of default. The appellate court rejected the argument. Now the appellant is saying that Federation is a regulated tenancy and that Federation should have gave a 90-day notice. In support of that argument, respondent and appellant asserted the following facts that are decorous to the record. Following the expiration of initial lease, petitioner accepted rent, the Federation accepted rent, creating a month-to-month tenancy. Subject premises is scattered site housing unit.
I mean, but can't we see from the record that he resided in the place for 2 years? Isn't that all we need to know?
No, well, that's
Well, I guess first question, can we see from the record that he resided there for 2 years?
No, and I was just about to explain why. The Federation has 800 units, apartments, that we rent out. Federation subsidizes the rent for these individuals. It's independent living. However, Federation does move the people around from unit to unit. So, for example, if somebody's not getting along with their roommate or they need a higher level of care, they move. And as you could see from the lease agreement, there is no term in the lease agreement, nor is there even a reference to an address as to where the individual
Then it's
resides.
the Federation's position that he resided there for less than 2 years, taking it out of the 90-day notice that would be required?
Well, my position is
Or is
that
it that they can't show it either one way or the other?
he can't show it one way or the other because it wasn't argued in the lower court. He switched, Lindsay switched his arguments midway. He argued one thing in the civil court and in the appellate term. And then I get a brief that has totally different arguments saying we're rent regulated, that we're subject to the rent stabilization code, which is untrue. We're not a charitable organization, and our tenants are not at risk for homelessness.
But do we have to find that, do we have to even reach the issue of rent regulation to determine that the notice of termination should have given him 90 days to get out as opposed
No.
to 30 days?
No, it has nothing to do with rent. We track,
issues.
but this is counsel's argument, and that's why I was addressing that. But there are facts. This is not pure law, where you can make a decision on the record. There are facts that are missing from the record. I didn't choose Lindsay's argument that he made before the civil court. And the judge in the civil court said that there are additional facts that are required in a notice of termination. That is not true. If you look at 232A, the notice tracks the language, and the appellate term was correct in its decision.
Is there a debate that this gentleman has always resided in the building? Maybe he's not residing in the same apartment, but he's always resided in the building since the lease was signed back in March 12 of 2020.
That's my point, Your Honor. The record doesn't bear that he's been in this building since 2020. We have units all over the city, so it's not uncommon where I start a summary proceeding against somebody, and all of a sudden they're moved out to another proceeding because their roommate is dangerous. There's a problem going on in a particular unit. So that should have been an argument that was raised in the lower court, in the civil court, and it was not raised. There is no record of that type of fact, which should have been raised by the appellant.
So how is the predicate notice sufficient?
The predicate notice is sufficient because we followed the sublease agreement. We gave a notice of default, which contained a notice of cure, a 30-day notice of default. At that point, we gave after the term expired, we gave a notice of termination, and we afforded the defendant was able, the respondent in this case, was able to formulate a defense. We told the other side that they assaulted the superintendent and made threats to the superintendent and assaulted the staff.
That was the notice of default.
That was in the notice of default. That's correct.
Right, the notice of termination didn't state that.
No, the notice of termination tracked the language of 232A.
Yes.
And that's what the appellate term agreed with the Federation.
Thank you.
Thank you.
The critical issue that this court needs to focus on is this termination notice, the 232A termination notice. It is the self-same notice that any landlord in the city of New York can serve on any tenant who's a month-to-month tenant who can be evicted at will. This is a supportive housing tenancy. The lease clearly provides protections against no-cause evictions. The termination notice needs...
So the time of the notice is not an issue here because it's been posited that we shouldn't even have to get that far because the 30 days, 90 days, there's nothing in the record.
We also argue that the record is clear that Mr. Lindsay has resided in this...
How is it clear?
He signed a lease in March of 2020. He's been in the same apartment since.
And there's been nothing...
You got chapter and verse on that? I'm sorry to interrupt. Where in the record is it reflected?
I direct your honor to the lease, which is at record page 12.
Right, but what about residing in the same spot for 2 years? I don't want to take up the rest of your time, counsel, but is that somewhere in your brief?
It's not apparent in the four corners of the lease itself, but there's been no contrary evidence adduced
Also, I apologize for interrupting. Was that the question?
That was, yes.
Okay.
So was this argued before civil court as well as before the appellate term?
Your Honor, you're referring to the...
The lease and him having been on the premises in the residence for 2 years.
Now, the RPL 226C argument about the 30, 60, 90-day notice, this was not raised at civil court. It was not raised at the appellate term. I'd submit, Your Honor, that, again, the critical issue is we have a supportive housing tenant with a lease that provides protections against no-cause holdover evictions. Clearly, the lease provides that if there's a material breach, there needs to be a notice of default, followed by a breach of lease holdover proceeding. And the law for 30 years under Chinatown Apartments, City of Buffalo Urban Renewal Agency, says that a termination notice needs to be clear, unambiguous, allow a tenant to prepare a defense to protect their leasehold interest and to protect against the devastating consequences of an eviction.
Thank you. Thank you both.
Thank you.
Italia Special versus Sustainable Opportunities. Yes, you may proceed.
May it please the court, Samir Degasen for appellant. This case involves a group of sophisticated investors who wish to unwind a transaction they regret based on hindsight pleading. I want to make 3 key points. First, the crux of plaintiff's claim is that TMC was required to publicly state in its SEC filings that Ramos would honor its funding commitment. But that argument is squarely foreclosed by this court's recent decision in Camelot, which the trial court here did not have the benefit of. In Camelot, the plaintiffs made virtually identical allegations that issuers and underwriters should have known about a third party's inability to make its funding commitments and then should have disclosed it to the market. And this court rejected that argument. It held that a company cannot be liable for failing to disclose, quote, what it does not know. The same is true here. Plaintiffs do not allege that TMC knew any material non-public information about Ramos's internal financials. To the contrary, they acknowledge that TMC was defrauded by Ramos. Second, plaintiffs try to confuse the scope of the warranty here. The warranty in Section 6E was not a warranty that Ramos would follow through on its financial commitments. It was a warranty that TMC didn't lie on its SEC form.
Counsel, as you know, for 6E, they break it down. Your opponent breaks it down into 2 clauses and say that your interpretation would essentially nullify one of the clauses. Would you respond to that?
Yeah, I don't think that's true because the first clause just...
Basically, it seems like in your reply you're saying it's okay to be redundant, and I don't really see that as being a real principle of contract interpretation.
I mean, I think it is okay to be redundant if it's just to clarify something, but here it's not redundant because Section 11 and Section 12, which is the language that's being parroted in that second clause, didn't, certainly in 2021, and I think still today, don't necessarily apply to a pipe transaction. The Supreme Court in Gustafson said that Section 12 only applies in an IPO, and this wasn't an IPO. So I think what that provision is doing is saying that language in Section 12 that may not otherwise apply just under the ordinary securities laws applies to this transaction, imports that language from Section 12. So I don't think it is superfluous. And I think ultimately, we agree this is a breach of contract case, and you have to interpret the language of the contract. But because the contract mimics, I think everyone agrees it's the exact same language essentially that's in Section 12. And so cases interpreting those same words in Section 12 have force here. I mean, ultimately, you interpret statutes and you interpret contracts in the same way, which is that you look to their plain meaning. And as this court explained in Camelot and followed, decades of federal court precedent interpreting this exact same language, to omit something, you have to know it in the first place. You can't omit something that you don't have. Omitting is kind of this volitional act if you have the material non-public information and you choose not to include it. But if you don't know something at all...
Were there any red flags about Ramos? That its corporate headquarters was a 2-bedroom apartment, didn't specify how many baths, but, and that there was the defaulted upon credit card bill. I mean, were there any things that you all knew that...
No. I mean, they don't allege a single fact that was in our possession that was not public information. And they don't allege that we knew any of those things. That, I think, is what's remarkable about this case. And just to note the things that you mentioned there, there's a default judgment that was filed on August 17th. That was after the last SEC filing. And we only warranted, the language of the contract only warrants as of the time of the SEC filing. Then they mentioned the state court lawsuit. That was months later. That was in November 11. That was after even the closing of the pipe. And then those are the only two facts that they identify. And then the residential address, we disclose that.
Does the size of the percentage size of this investment in this particular pipe, does that mean that there's a greater obligation for due diligence?
I don't think so. I mean, so we disclosed exactly who Ramos was, their residential address, and also they knew that they were that they were going to be 20 million shares for Ramos. You know, that was 20,000 shares for Ramos. They knew exactly how much Ramos's commitment was going to be, and I think that's the important thing here. Is this contract does not actually call for any diligence on co-investors. That's how they try to frame it. But this contract actually says the opposite. If you look at section 7L of the contract, it says, in making its decision to purchase the shares, the investor has relied solely upon independent investigation by the investor.
Should we be concerned from a policy point of view that pipes are often used instead of public financing because they're faster and they're less regulated? So should we be paying more attention to them, and allow such breach of contract claims, at least at a pleading stage, just to make sure that pipes don't end up with a lot of people losing money?
I think you have to interpret the contract according to its terms. They could have negotiated for a different contract that did impose diligence obligations on us. Instead, what they said is they did an independent investigation, and this is the other key phrase, section 7H. The investor acknowledges and agrees that the investor has received such information as the investor deems necessary in order to make an investment decision with respect to the shares, and had the full opportunity to ask such questions, receive such answers, and obtain such information as the investor has deemed necessary to make a decision. And then importantly, their subscription agreement irrevocably commits them to the purchase of shares, and they're obligated to consummate the transaction, regardless of whether any other co-investor goes through with their transaction. So they could have structured this transaction differently, and pipes often are structured in a way where they say, if other co-investors don't go through with it, then we won't go through with it either. Or they could have said, we need you to do more diligence, or they could have done their own independent diligence. They did none of those things. They believed in the company, they believed in the share price. Now things haven't gone well for them. They didn't go well for us either. We were the victims of this just as much as anyone, as the SEC found. The SEC took a close look at this, and they found that we were the victims of fraud and that we did not commit any fraud. So, we were equally the victims, but now they regret that transaction and they want to unwind it. But the provision that they've hunted around for, all it says is we didn't lie on our SEC forms. And, as this court held in Camelot, the Camelot facts are far more egregious, I think, than the facts in this case. In Camelot, the issue of Viacom made...
You have time on rebuttal.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, Jeffrey Abraham for plaintiffs.
Counsel, if you could just pick up that thread about the Camelot case and how it applies to these particular facts.
Well, first of all, I think that my colleague is kind of mixing apples and oranges, because this is a state law breach of contract claim. Provision 7L basically precludes my clients from bringing misrepresentation claims. But the claim here is that there's a warranty. And as Justice Reed found, when you make a warranty, it imposes upon you the obligation to do due diligence. And under the Court of Appeals decision in CBS, that warranty is ironclad. You are fully responsible for it. Everybody here is a sophisticated party. My colleague's client, the company, is a sophisticated party. They warranted that the pipe was fully upsized and committed. It's clearly a misrepresentation of fact, materially misleading.
But the facts about Ramos didn't come to light until much later, right?
It's not clear that they didn't come to light till much later. That's what the company would like to say, but because they tried to get away from disclosing Ramos fully, the SEC forced them to disclose Ramos's full participation. It's alleged in our complaint. They try to say All Seas was the anchor investor. And it's not clear on the record what they knew or what they didn't know.
And this is a 3211?
Sorry,
motion?
Your Honor? The size of the pipe was 330 million.
No, no, I'm talking about the stage of the pleadings. We're here at 30,
It
it's
is a
not summary
breach of, it is a
judgment, right?
breach of contract case. We have not had this, when we filed this complaint, we had not had pretrial discovery, and there is none that's referenced in the record. This is simply a breach of contract case, and it's not clear what defendants knew or what they were reckless in disregarding based upon the events. That's not in the record. But what is clear is that Ramos was not able to ever satisfy the $200 million. Not only was it run out of a two-bedroom apartment, but it had $11 in the bank. Not only that, previously they hadn't been able to fund a $1 million commitment and had been sued. The general partner or the controlling managing member was being sued by American Express for $15,000.
These facts would be clearer once there was discovery, right? Because my colleague mentioned
This will be
the
absolutely
32
clear. And I also want to point out that there is no risk factor that defendants identify in their brief that says, well, there's a risk if the subscribers don't subscribe. There is a risk that we have our largest subscriber subscribing for more than half the pipe, who has no money, who might have no money, certainly has no track history. That is not the risk factor that they disclosed. They didn't disclose anything like that. They disclosed stuff about the operations. And this $200 million is not an idle number, because before our clients invested, basically SOAC was a shell company, a blank check company. And I'd like you to hold that thought in mind, Your Honors. And they needed this funding to get to the development stage. What they had after this offering was over, because of the Ramos's failure to fund, and then other investors refusing to pony up because they may have found out about that, is another underfunded company which had to sell stock at a 90% discount to what was in the offering. And, Your Honor, you should be aware that with respect to the analogy to Section 12, which is not mentioned in the contract, and these were sophisticated parties who could have said, for example, in the warranty that consistent with Section 12A2, they could have said something like that, but they didn't. That under the Securities Act, in a blank check company situation, the safe harbor provision does not apply. It's a more stringent situation. They were taking in money. I understand their motivation for taking in money. It's a breach of contract claim. They had their largest investor, did not have the money. And based upon the facts as they existed at the time the statements were made and at the time the closing took place, at which time the company reaffirmed its representations and recommitted to the warranty, there was no way that Ramos could pony up $200 million. So maybe they'll prove that they didn't know, but I don't even think that's important under a breach of warranty claim. You warrant something to be true. The contract doesn't transform a basic breach of contract claim into a securities law claim. There are analogies to securities law, but it doesn't transform the claim unless the contract clause says explicitly, mentions that you could only sue under Section 12A2 or in a case analogous to Section 12A2. And in that regard, the defendant ignores the Sasson case of this court, which explains that when there's an and as a conjunction, each clause stands independently. That last clause stands independently. There are similar cases in New York interpreting language very similar to that, including the Nomura Securities case we cite, which involves the sale of securities. The Court of Appeals and none of the other courts in that case ever analyzed the case under anything other than a breach of contract claims. You make a warranty, you're giving an ironclad promise that those facts are true. And even if that's not the case, Your Honors, it's still on the pleading stage, and there's no facts to demonstrate otherwise, Your Honor.
Thank you.
Thank you, Your Honor. We're not disputing that this is a warranty case, and the question is, what did we warrant? And I think the implication there is that we warranted that Ramos would follow through on their transaction, but that's not what Section 6E says. We warranted that we didn't tell a lie on our SEC forms, and the warranty is that language that tracks the language of Section 12.
Not just that you didn't tell a lie, but that you did not leave anything out that would cause your statements to be misleading.
Exactly, that we didn't leave, and what this court said in Camelot is that word omit, that when you don't leave something out, the things that refers to are things that are in your possession. And there is not a single case in this court, a breach of contract case, a federal securities case, in any case that says that if you don't have the information, what you're supposed to do is go discover the information from another company.
That's what they're saying. They're saying we don't know if they had the information when they filled out this form.
Yeah,
and we need discovery to find out what they knew at the time that they filled out this form.
Right, and that's not the standard. They can't just say it's theoretically possible. They have to plead facts that at least suggest that there is something there. And Camelot was a pleadings case. It was a pleadings case, and here are the facts that were involved in Camelot. The underwriters and issuers knew that Archegos represented 34% of Viacom's overall market capitalization. The underwriters there, it was in the complaint, were counting on Archegos to be the anchor investor of Viacom's IPO. Archegos was a family-run firm that was headed by someone who had previously had an insider trading conviction.
But they pled. It says they pled that you omitted material facts in your filings regarding the financial situation of Ramos. But why is that not sufficient at this pleading stage? And then we will proceed to discovery and flesh it out.
Because that's just a legal conclusion. They have to identify what are the facts that we have in our possession. And I don't know a single case that allows even to go past the pleading stage based on the idea that just complete speculation that we may have known something. They have to have some factual basis for that. And I think what is glaring, what is remarkable about this case, is they can't point to a single piece of information that was in our possession. When they try to point to the information, all of the information is stuff that's outside of our possession that we're not alleged to know or that's already in the public domain. And there's just no case like that. And I do think Camelot just controls.
Thank you. Thank you both.
Case, Your Honor. Thank you.
Trotman v. Precision Elevator. Yes, you may proceed.
Good afternoon, Your Honors. I'm sorry, good morning, Your Honors. It's Friday. May it please the court, Michael Zhu. I'm appellate counsel to Morgan Levine Dolan, attorneys of record for the plaintiff, Glendale Trotman. The lower court here erred in denying my motion for partial summary judgment and granting the defendant's motion for summary judgment.
Well, would it be fair to say that if the trial court erred in denying your motion for summary judgment, maybe they likewise should have denied the motion for summary judgment, the cross motion from the defendants because of issues of fact? I mean, why would you be entitled to summary judgment based upon your motion when these kinds of cases might hinge on credibility? There are competing experts. I note that your expert didn't really address one of the issues, the lights shutting off, the power going off as the reason for the elevator stoppage or quick descension.
The defense in this claim that it was mechanically impossible and that it was caused by a power outage really finds no support in the record. Because in addition to the elevator lights...
But your expert does not contradict that in any way.
Well, but the facts do. The facts contradict that because Mrs. Trotman testified that not only did the lights go on and off, but it dropped and then it went back up. And so the power loss, and then after it went back up, it shook up and down. So the power loss doesn't explain the erratic behavior. It may have caused the elevator to stop, but there's no explanation for why it dropped, and then it went back up, and then the doors opened in between floors, and then it closed in between floors, and then eventually went back up to the sixth floor, even though she pressed the fifth floor. So even if you could explain...
I thought Mr. Halpern said that both things could happen.
I'm sorry, what?
Mr. Halpern's the expert. We're talking about precision's
For the
expert.
defendant, yes.
I thought he said that electrical failure could cause both the twinkling of the lights or the turning off of the lights and the movement of the elevator.
But that testimony is refuted by Roman Shupta's testimony, where he was asked very specifically at 10:11 through 10:13 of the record, 6 questions, 3 relating to broken wires, 3 relating to loose wires, which is all part of the controller. And he was asked, does a broken wire or loose wire cause an elevator to 1, drop and stop, 2, behave erratically, or 3, open its doors in between floors? And as to each of these 6 questions, he answered, yes, it does.
Right. So that creates an issue of fact, maybe. But again, with respect to precision's expert, he gives a totally different theory, which is it doesn't have anything to do with the wires. It just has to do like an external force, i.e. Con Ed, cut off the power somehow, or something happened to the power that having nothing to do with the mechanics of the elevator, and that caused.
But the defendant cannot create its own issue of fact. He's ignoring his own client's elevator mechanic's testimony.
How do you pronounce his name, Mr. Shibuya?
I disagreed with any of that. What really happened was a power loss. An expert for a defendant in moving for summary judgment cannot simply say, there's a power loss and I don't care what my client testified to, because my client testified to things.
No, Mr. Shibuya, is it Shibuya? Is that how you pronounce it?
Shibuya, yeah, Shibuya.
His testimony is great for you.
I'm sorry?
His testimony creates an issue of fact, I think.
Well, no.
In your favor.
I respect.
No, you want to go the whole way. Yeah.
His testimony establishes my prima facie entitlement.
You have too many people giving too many etiologies of this accident to get summary judgment, in my opinion. I don't speak for the panel.
Look, if at worst, my motion is denied and his motion is denied, I can live with that, because at least Mrs. Trotman gets to have her day in court. Thank you.
Good morning, Your Honors. May it please the Court, Desiree Berger on behalf of Respondent Precision Elevator Corp. I just want to emphasize a couple points that my colleague highlighted. First, this court is correct that the expert affidavit that we submitted, John Halpern, he submits that if we assume that what plaintiff testified that the elevator did is true, the only explanation for that could be an external power loss.
Here's the thing about that, counsel, because even if we were to ignore both experts, we don't even have to read there, your own elevator mechanic doesn't testify favorably for you. Why isn't that a question of fact? What entitles you to summary judgment?
I disagree, Your Honor, that he doesn't testify favorably for us. His testimony is actually specifically that these kinds of elevators are extremely old. They're single-speed AC elevators. The elevator at this particular time was over 90 years old. He was specifically asked questions about the wire on the controller that we found when we responded to the building. And what he said was that it's not uncommon for elevators who are so old to have issues on the controller, but regardless, that does not necessarily mean that the elevator would have behaved the way that the plaintiff here is saying it did. And then that's further supported with the expert affidavit of John Halpern.
How is that good for you?
I'm sorry?
How is that good for you?
It means that the elevator, if we assume that what plaintiff's saying, which the experts say it's not mechanically possible, but if we assume, for the sake of argument, what it means is that this happened not based on a negligent act or an omission of the elevator company, but an external force that has absolutely that we, as the maintaining company, has no control over. Specifically, the controller that plaintiff keeps harping on, the loose wire, is a completely separate component than the electrical outlet in an elevator.
Well, he said he didn't know when the brake system was installed. He didn't know its useful life. He didn't know, apparently Precision had made a proposal for modernizing the elevator. He didn't know whether that had occurred. Basically he was saying that the elevator, a worn relay could cause the elevator to malfunction.
Right, but malfunction here, Your Honor, we need to be very specific about the language that we're using, because the plaintiff is claiming the following. The plaintiff is claiming that she got onto the elevator without no issues. She took it up between the 6th and 7th floor. It stopped between floors. She was not injured when it stopped between floors. The lights went off. It was then stationary for 30 minutes. In that time, the doors slightly opened, they closed, the lights came back on, the elevator descended to the basement, the doors opened, plaintiff exits, gets back on the elevator, and then takes it up to the floor where she was originally going. Frankly, there is nothing that Mr. Carriger, plaintiff's expert, submits that can combat the explanation of the fact that it was an external power loss. Mechanics with 20, 30 plus years of experience agree that if we assume that what plaintiff says is true, specifically about the lights, because that's very critically here, because that's a completely separate component than the mechanical controller as opposed to an electrical force. And Carriger simply does not deal with that. And that is the critical issue here. And that is what the lower court decided. And that's why they decided that defendants are entitled to summary judgment here. It's really a matter of plaintiff's expert egregiously not addressing that issue.
How about the testimony of your own witness? Again, I think we're repeating ourselves, which is found on record pages 1011 through 1013, where he is asked specifically whether or not a loose or broken wire would cause the elevator to behave in the manner that the plaintiff described, and he answers yes. Wouldn't that create an issue of fact?
No, Your Honor, because that's—
Why not?
It's a misconstruing of his exact testimony. That's not exactly what he said. He said it may cause something like the doors to open or the elevator to stop between floors, because as we're talking here, this is a mechanical controller, right? Its job is to tell the elevator when to stop. However, that would not deal with the fact that the lights went out at the same time. Taking apart the—
But you're saying that the elevator behaved the way it did because the lights went out. He's asked whether or not a loose wire, which was found on the date of the incident, when he went to the premises to repair the elevator, he found that there was a relay, or the control board had a loose wire somewhere, which he had to repair, and he was asked whether or not that would cause the elevator to behave in the manner that the plaintiff described, and he answered yes to every question he was asked. So how is not that an issue for the jury to decide? Who do they believe, your expert or your witness?
Again, Your Honor, I respectfully disagree that that's not the testimony, the exact precise testimony of Mr. Shibuya. He specifically said that it would cause the elevator to stop between floors. But again, there's nothing except for our expert affidavit that correlates, yes, that the elevator did stop between floors, and perhaps that had something to do with the wiring. But we're forgetting that plaintiff also testified about the lights, and that's the critical issue here.
You're putting a lot of emphasis on the lights and the lights going out as opposed to everything else that occurred. Because you're emphasizing because the lights went out, that must have been a power outage. But what about everything else that occurred?
Yes, because, Your Honor, if you read John Halpern's affidavit, what he says is—
I'm looking at his affidavit.
Yes, that this could happen. But the only explanation for the lights going out at the same time, that it's stopping between floors, could only be attributed to an external power failure that doesn't have—
Isn't that also an issue of credibility that the jury would decide in terms of, she's stuck in the elevators going up and down, things are occurring. Maybe the lights went out when it hit the basement. Maybe the lights went out when it went up. I mean, her statements in terms of what occurred, it wasn't like, okay, the first minute this occurred, the second minute the lights went out, the third, again, would this not be an issue of credibility for the jury to assess?
No, Your Honor, and respectfully, I would argue that the lower court properly examined the expert affidavits and adequately concluded that, especially this court specifically, has held that Mr. Carriger constantly makes speculative conclusions of law and fact, and just like he did here, specifically because he just completely omits the testimony about the lights. He doesn't deal with it at all. We deal with it in that we completely address it and agree that plaintiff did testify that this happened, but that's the critical issue here. Plaintiff's expert is the one that's being speculative. Plaintiff's expert is the one that's making conclusions not supported by plaintiff's own testimony here. So, with that, thank you, Your Honor.
Given the court's position on the questioning, I'll waive my time on rebuttal. Thank you.
Thank you. Valkyrie AI versus Price Waterhouse Coopers.
May it please the court, Avi Weitzman of Paul Hastings on behalf of appellant cross-respondent PwC. With me in the first row is Brendan Snodgrass, client representative of principal at PwC and a member of the General Counsel's office. At its core, this appeal presents a straightforward question. Can a company be sued for hiring an employee who's alleged to have breached restrictive covenants and disclosed or used trade secrets in his new employment? And the answer to that simple, straightforward question is similarly simple and straightforward. No, not unless the new employer has engaged in some wrongdoing to obtain the trade secrets or cause the breach of the restrictive covenants.
You don't dispute that the complaint adequately alleges that PwC was aware of the restrictive agreements?
Correct, Your Honor. It does allege that. And the law is clear that knowledge of restrictive agreements alone does not constitute a tortious interference with the restrictive covenants. And I would point Your Honor to...
It's okay, you don't need to.
Yeah, knowledge alone would just be a mere negligence. It wouldn't be an intentional procurement of the tortious interference.
Right, but then the Brown affidavit goes on, and doesn't that fill in any gaps concerning the misappropriation of trade secrets?
It does not. The Brown affidavit only fills in the gaps as to what the trade secret is, according to the judge, but it doesn't identify any conduct by PwC that was wrongful in obtaining the trade secrets or causing Miraglia to use the trade secrets in connection with his employment. In fact, there isn't any allegation that Miraglia did use the trade secrets. The field that we're talking about... Yeah.
We're all, rational people here. I mean, why would they hire Miraglia in the first place? You got to think about the context, the larger context. And I know PwC had a prior relationship with the client, and you wanted to expand that relationship, but you're hiring someone who's specifically working on an AI project with specific AI products. And so how could it not know that they might run afoul, at least for the pleading stage, at where we're at? How could they, isn't there enough here in terms of context to say that PwC was aware that Miraglia would be breaching these agreements?
I don't believe so, Your Honor. So a few things. First of all, this was an acquisition of Sagents, a much larger company than Miraglia, many dozens of employees. Miraglia came along with a job. PwC has a long-term relationship with Morgan Stanley. Morgan Stanley wanted the job to continue, and therefore they put Miraglia on the job. Look at the provision of the subcontractor agreement that is alleged to be breached. Remember, there's no tortious interference of contract claim with respect to the Morgan Stanley contract. That contract ended on its own accord. There's no allegation that the contract was breached or that PwC tortiously interfered with that contract. The tortious interference claim is as to the subcontractor agreement, and there's a non-solicitation provision in that subcontractor agreement. That non-solicitation, there's no allegation, no specific particularized allegation that that non-solicitation agreement was breached. There's no allegation as to how Sagents or Miraglia breached the subcontractor agreement specifically and solicited Morgan Stanley, and in fact, it doesn't make sense.
Wasn't he encouraged to work on the same project, in the same position on the same project for the same client?
There is no such allegation in the complaint. The allegation in the complaint, that's an allegation that they put in their opposition brief, but in the complaint, all it says is that he took off the proverbial reclassify hat and put on a proverbial PwC hat. There's no allegation that PwC directed him to do anything like use the trade secrets. In fact, if you believe that this is a trade secret, as the plaintiff alleges, then there's multiple different ways in which you can perform this job. There's no specific allegation that the way he performed the job at PwC was using the trade secret, or at least no particularized.
He's performing the same job for the same job for the same client.
Correct, Your Honor, and there's nothing.
So why then would he in any way change the way he's performing because he's working for PwC?
When you look,
because he's now working for PwC. When it's the same client, he's doing the same work for the same client. Why is he going to change now because he's working for PwC?
When you look at what PwC knew, PwC had in due diligence the subcontractor agreement. That subcontractor agreement says that someone like Miraglia or Sagents is going to work at Morgan Stanley's direction in performing its tasks. It's in.
I don't.
And so the assumption
there were restrictive covenants in this case applying to Miraglia and Sagents, right?
Say that again?
They were restrictive agreements, rather,
Yes.
applying.
There's a non-solicitation provision.
Right. And then PwC is aware of these restrictive agreements. And it's alleged that even though they are aware of these restrictive agreements, they still solicit Miraglia and Sagents to perform the same work that they were doing with Reclassify and Morgan Stanley, but now do it for PwC. Why isn't that enough at the pleading stage? I mean, maybe on summary judgment, it'll be something different, but we're at the pleading stage here.
At the pleading stage, you at least have to allege what the breach was. There's no allegation as to how Sagents or Miraglia solicited Morgan Stanley. In fact, the allegation is the opposite, that PwC had the relationship with Morgan Stanley. And so there wouldn't have been a breach even on the face of the contract with respect to the non-solicitation provision. It's titled a non-compete provision, but that's not what the provision says, and it's part of the record below.
But again, Maglia is working for the same client now for PwC. So why would Maglia not be aware of the fact that they may be running afoul of the restricted agreement?
He may be, but that doesn't impose liability on PwC. Miraglia will be a defendant in this case either way.
Again, we're at the pleading stage, right?
Correct.
And so discovery, again, would flesh these issues out. You do have time on rebuttal.
Thank you, Your Honor.
Good morning, Your Honors. Wallace Neal for Reclassify. Briefly, a few points that Your Honors mentioned I think could clear some things up. First of all, in the record, paragraph 64 of the complaint on page 85 of the record says, PwC and Sagents thus pocketed Reclassify's know-how, trade secrets, and methods, and then took over Reclassify's LCD innovation project at Morgan Stanley and ran it without interruption with Miraglia in the same spot. They essentially, nothing changed from the Morgan Stanley side except who they wrote the check to at the end of the for the work
Same
on the
client.
project. Yeah,
Same client, same
person.
work.
As I said, he took off one hat, he put on the other, but to the outside observer, it was completely uninterrupted. He did the same thing on the same.
Anything that there was any direction now to Maglia that he was to any way change the way in which he was doing the work?
Not to my knowledge, but we wouldn't know that until discovery comes through. Secondly, the questions with regard to the restrictive covenants, which Your Honors asked. There's also an NDA. I mean, it's not just the non-solicitation, non-compete, it's the NDA. And that's, I mean, to the extent that we're on the trade secret, that to me is the pinnacle of the breaches. There's an NDA that he would, again, one hat off, other hat on, keep doing the same work. I don't see how they get around that, particularly as Your Honor knows, at the pleading stage.
Well, the argument was that how would they know what he was doing?
They directed him to do it. Like, he's working for them now. They own him. So at that point, they can't say we don't know what this guy was doing. He had a PwC crest right on his shirt for all purposes. He's doing work for them, for Morgan Stanley. Morgan Stanley's paying PwC. Yes.
Isn't the issue of whether the information was trade secret a issue of fact that really has to be fleshed out?
Yes, and in fact, we are deep into supplemental interrogatories and a deposition on that particular point now. So I think that addresses Your Honor's questions on that point. Quickly, in my remaining time, with regard to the cross appeal, I'll just note that, one moment.
Yeah, the problem there, so that's the tortious interference with prospective business relations.
Prospective, yes, Your Honor.
How do you know you were going to get another contract with Morgan?
Well, we were on number 2, which they quickly renewed. We are an AI startup. Excuse me. No reason to think that this isn't going to happen. I would, I would note that I would bet my bottom dollar that there was a third in the hands of Price Waterhouse. So the idea that it wouldn't have been renewed in our hands, but it was renewed in theirs, is it takes a lot of believing. Let's say. If there's nothing more on that, then to the cross appeal. Quickly, the tortious interference with prospective. I'm sorry, we're on the cross appeal. The other elements, I think, are undisputed. Did they know of the contract? Yes. Was it interfered with? Yes. Were wrongful means used? Unfair competition is a wrongful mean. And was there injury?
Is that not that part? Is that not duplicative of the unfair?
Yeah, and that's what Justice Schechter said in part. I think, to me, the better view on that is to let them both go forward. Just because they're duplicative doesn't mean that they both have to go away, particularly at the pleading stage. Let's go, let's take discovery, and if there has to be a motion for summary judgment on one or both at a later stage, let's have that. But in the meantime, let's make discovery as broad as we have to so we don't have to go back and do it again. If the bench has nothing else, I'll reserve my rebuttal.
Yeah.
Good morning, Your Honors. Brennan Breland, Kaufman, Borgeston, Ryan for defendants, respondents, Sagents, Sagents Incorporated, and Pierre Luigi Miraglia. May it please the court. This court should affirm the order below, whereby the New York County Supreme Court dismissed, reclassifies tortious interference with prospective contract claim on the ground that it was duplicative of its unfair competition claim. Although I will rest on my brief for the issues addressed therein, there are a few matters that have been raised since the filing of the initial briefs in this case that I'd like to address. First, I want to note that reclassify doesn't address the fact that the Supreme Court dismissed the tortious interference claim. And when I refer to tortious interference, I'm referring to the prospective contract, not dismissed the tortious interference claim because it was duplicative of the unfair competition claim. It should not be permitted to argue this point in reply, or should not be understood. Should not be heard to argue that point today. You'll note that in the initial brief for reclassify, their argument was that the trial court's dismissal should be reversed because they stated a claim sufficient to survive dismissal under CPLR 3211A7, which is not the point we're arguing today. Second, reclassify cites in their reply papers the case of Foster versus Kovner for the proposition that the tortious interference and unfair competition claims should proceed together in order to permit discovery as to punitive damages. That case, however, held that where the Supreme Court noted its tendency to dismiss breach of fiduciary duty claims as duplicative of contract breach claims, even where the underlying contract is not enforceable, the Supreme Court below dismissed the breach of fiduciary duty claim because of an erroneous application of the statute of frauds, rendering an underlying joint venture agreement unenforceable. This court reversed on the basis that that analysis, that the statute of frauds renders the joint venture agreement unenforceable, was erroneous, and therefore reversed the dismissal on that basis. Accordingly, because there's no underlying interpretive or contract construction error here, this case is inapposite. Third, the fact that reclassify seeks punitive damages in this case does not obviate the duplicative character of these claims as noted by Justice Schechter below, and they've given no reason on appeal to disturb that analysis. Fourth, reclassify argues in reply that the unfair competition is a sufficient wrongful means for the tortious interference claim. But as noted, this is raised for the first time on appeal and is additionally inadequately pled in itself. And finally, reclassify argues in reply that malice is not required. Subjective intent to harm reclassify is not required to have been pled because of the use of wrongful means, because they never establish any sort of anti-competitive restrictions on trade as contemplated by the creative trading case cited in our brief, et cetera. There's no indication that the defendants acted in anything other than rational economic self-interest, and there's no adequate showing of
Do they have to
wrongful
affirmatively plead that, or they just, I mean, that's a good possible defense by you all, that's your economic interest defense, okay, but do they have to like plead around that and anticipate you're making that defense? I don't think so.
Well, I mean, that's one of several avenues that they can use to get to wrongful means, but if they're not going to do that, they're certainly under no obligation to do that. They did not satisfy any of the other options that allow them to adequately plead that, as the underlying wrongful means is facially inadequate itself. Absent any further questions from the bench, I rest my briefs.
Thank you.
A few brief points, Your Honor. With respect to the trade secret claim, which is really the unfair competition claim, there is no allegation of bad faith or improper means by PwC. When you look at the complaint, there is an allegation that Miraglia and Sagents engaged in bad faith. That's complaint allegation 58. But then when you look at PwC, there is no such allegation, and that's a fundamental element. In fact, as Your Honor knows from the Schroeder case Your Honor decided back in 2019, Schroeder v. Cohen, the predecessor opinion in that case was Schroeder v. Pinterest. You can replace Pinterest in that entire case with PwC, and you'd get the exact same ruling, which is that you would dismiss the motion, you would dismiss at the pleading stage PwC or Pinterest in that case, because voluntarily turning over or using trade secrets alone is not sufficient. You have to show that the employer engaged in bad faith or improper means to obtain that trade secret.
And we draw an inference from the discussions about forming a JBR, a joint business relationship with the plaintiff.
I don't believe so, Your Honor. And the reason
Did that show a guilty conscience?
That shows what?
Does it show a guilty conscience?
Not at all. First of all, the allegation is that Sagents suggested that that Reclassify.
Yeah, but I thought there's something about PwC strategizing with Sagents. I may be mistaken.
There's a statement that Sagents says maybe PwC will be willing to enter into JBR. PwC never proposes it, discusses it, or negotiates it. In any event, there's no allegation of any reliance on the part of Reclassify on that offer. So for instance, if Reclassify had said, ooh, a JBR, let me disclose now the trade secrets to you, and they relied on it, but they didn't do anything with that. That's not an improper, I mean, PwC could have offered a JBR, they could have not offered a JBR, it's within their right. There's nothing improper about that suggestion. The next point I'd like to make is mere knowledge of either the restricted covenants or the trade secret is insufficient, and that's under binding law. So, Your Honor, I refer you to both the Prospect Funding Holdings case and the Beecher v. Feldstein cases, both of which are cited in our briefs, and they make very clear that when a party knows of a restricted covenant, that's insufficient, or even that a restrictive covenant will be breached, it's insufficient unless the party induces the breach. And there's nothing here to suggest that PwC asked Miraglia to use trade secrets or violate his non-solicitation provision. The final point, Your Honors, is economic justification, which we've properly briefed, and it justifies
You're
transaction.
done.
Thank you, Your Honors.
I don't believe I'm permitted to respond on rebuttal to what was said there, but briefly with respect to with respect to what was said on the tortious interference with prospective contract, we'll stand on the papers for that. I think Your Honor's question earlier about whether this was guaranteed to continue or not, I think that is a question of fact for the jury, and I would just leave it at that. Thank you, Your Honors.
Thank you all. Mostock, yes, Mostock v. Hebrew Home for the Aged. Yes.
Morning, Your Honors. May it please the Court, Michael Zhu, Appellate Counsel to Parker Wakeman, attorneys of record for the plaintiff's appellants. The lower court here erred in granting the defendant's motion to dismiss the reckless disregard.
The gross negligence.
Well, I'm sorry, gross negligence and demand for punitive damages, because
How is this gross negligence? I mean, arguably, assuming it's negligence, right? What more could they have done for this gentleman who he would take off the helmet, he would not sit down, try to stand up? I mean, what more could have been done?
they didn't even follow their own care plan, which was close observation.
Well, they put him near the nurse's station, right?
And he fell in front and nobody saw it.
But then why isn't that just ordinary negligence? How is that
Because-
gross negligence?
Because it happened 24 times in a span of 3 years. Where you have a care plan that says this man is delirious, this man is uncooperative, this man does things that he shouldn't do. He stands up and he knows the chair's not there and he sits back
Is
down.
that malicious? Is that concerning the public? Is it wantonly dishonest? Like how is, I mean, maybe ordinary negligence, but gross negligence is a different standard.
Because it's a complete disregard for his well-being. You have a nursing home patient who relies on these professionals to safeguard him. If they can't do it, and the expert says, oh, we can't do one-to-one supervision here because it's not extraordinary, but she never explains what those situations are. So if you can't do it, then advise that maybe the family can transfer him to another facility who can provide these services, the services that he requires as a nursing patient. So, meaning, if you take on a patient and you collect money, because they sure made money all these years that he was in there, and they don't live up to the most basic fundamentals of what their practice requires.
One fundamental you have to concede that they did live up to is they adjusted his care plan, right? They did ramp up a little bit.
They did, but they never followed through, because how can you have close one-on-one, close supervision when they put him in a seat next to the nurse's station and he still falls, but nobody knows how it happened. So that means nobody was looking.
Well,
So that
wasn't
means-
wasn't there testimony that he was just like so quick? I mean, it just so happened so quickly that, you know, they would turn and he would just try to get up and then he would fall.
24 times, Your Honor. This isn't, look, I mean, I cited cases about abandonment and neglect. And
So your argument that it constituted gross negligence was because of the number of times that this gentleman ultimately fell and because they did not do more. What more should they have done?
one-on-one supervision. And if that's not something that they can provide, then
24-hour one-on-one supervision, someone who's going to stand there or sit there constantly in front of him?
But if that's what the care requires and they can't provide that, then transfer him somewhere else who can do that. Don't continue taking this man's money and denigrating his dignity in a situation like this. Look, I mean, this isn't just, oh, he went into the bathroom and supervised and he fell and he fractured his hip. There are tons of those cases, and those cases survive a summary judgment on negligence claims. But here we have, and these aren't just falls that were unwitnessed. I'm sorry, these aren't just falls. These are falls where it's documented. We don't know what happened. There was no one there. He was next to me, but I didn't see him fall. I mean, these are written in the defendant's own records. I don't see how they can survive. I'm sorry, I don't see how they meet their prima facie just based on their own records. At the very least, I'm not the one moving for summary judgment. I didn't ask for summary judgment on a reckless disregard standard. I didn't ask for that. I'm opposing their motion. If they have documented evidence of failure to supervise and failure to follow their care plan, then I don't see how a defendant can meet their burden on summary judgment, eliminating all issues of fact.
Are there nursing homes where people are one-on-one?
I don't know, but there's no testimony as to that. And that's not my burden, because I'm opposing summary judgment. So they can come forward and say, hey, this is all we could have done, and if you went anywhere else, you would have gotten the same care and treatment, and that's the best that anyone can do. Honestly, I do not know the answer to that, and that's not something that should have been resolved on summary judgment in defendant's favor. There was a second issue in terms of the modification of the medicines that he was taking, and Dr. Fox takes significant issue with the discontinuance of the Depakote. There's a disagreement amongst the experts, but the problem with the defendant's expert is she devotes one sentence in a 74-paragraph affirmation in support to the issue of the discontinuance of the Depakote. She doesn't even address that specifically. She just says they appropriately monitored and modified his medications. But Dr. Fox says that they discontinued it in July of 2009. And that's exactly when the falls began in earnest, because the combination of removing the Depakote and the cocktail of medicines that he was already on contributed excessively to his delirium, loss of balance, and his issues that he developed after that. And the defendant never properly addressed that. And so the failure to do that, in addition to the failure to comply with their own standards of care, should survive a defendant's motion for summary judgment. Thank you.
May it please the court, Stephen DeBraccio, Wilson Elster, on behalf of Respondent Hebrew Home.
So, counsel, it's a lot of falls. I mean, apparently, whatever plan was in place was obviously not working. Although he's by the nurse's station, he's still falling. So, why was not more done?
Yes, Your Honor.
And more in line, why was the failure to do more? Why does that not constitute gross negligence?
Yes, Your Honor. Plaintiff's counsel talks about 24 falls. But what's important here is
Decedent was admitted for 7 years. This is a 7-year admission, and the time between the first fall to the last fall was 3+ years. So in other words, it's not like he fell 24 times on one day and then nothing was done for 3 years about
But
it.
wasn't there a number of falls over a short period of time?
Yes, Your Honor, I believe in 2008 and 2009. And as defense expert noted, decedent's medication regimen was adjusted. He was afforded a helmet. Your Honor pointed that out. He was offered a walker, which he would not use. He was placed in the falling leaf program. He was closer supervised. Plaintiff's counsel mentioned how was he closer supervised if they didn't see the fall. He was closer supervised because CNA Murray testified she was there 3 seconds after he fell. And 3 seconds after that, other staff were there to take care of decedent.
Right, so, but why wasn't she there 3 seconds before? And then if she were there 3 seconds before, would she have not been able to, or 4 seconds before, would she not have been able to prevent him from falling?
Based on Dr. Wolf-Klein's affirmation, no, because she explained that falls can happen at a moment's notice, and even with the best of supervision, that is not a guarantee of preventing falls. But also, I'm sorry.
Go ahead.
But also, Your Honors, critical to this appeal is a gross negligence appeal. Defendants are not arguing whether we met the standard of care. The question is whether there is a tribal issue of fact, material fact, of gross negligence. And if I may, the key two cases to defendant in this issue is Ray versus Parkview, and this is discussed pages 46 to 48 of our brief, and Graham cited by plaintiff. And yes, we briefed them, but I bring them up because plaintiff never addresses Ray whatsoever in his moving or reply brief. And it was the very case that Supreme Court relied upon in granting the motion. In Ray, the decedent fell 4 times over a period of 3 weeks, and the nursing home demonstrated that they tried a wedge cushion, a seatbelt, and a recliner, and placing the decedent in a supine position in a recliner. She fell anyway. Irrespective of whether that raised a tribal issue of fact on ordinary negligence, as Your Honor pointed out, this is a gross negligence only appeal. Plaintiff's citation to Graham is of a different kind. In Graham, the physician was told the resident who was here and he's bleeding ate something, took a shower, and did not treat the resident for 5 hours. That is a level of scienter that is altogether different than what happened here.
But there are some cases that talk about grossly indifferent to patient care, right? So here, plaintiff's expert stated that there could have been a chair that was used as a specialized chair, apparently that has a seat belt. Also, alarms could be used, but none of these protections or devices were used. So why would that not constitute, or why would that not constitute grossly indifferent, being grossly indifferent to patient care?
The answer to that question, first of all, and this is important, as this is a gross negligence appeal, and this is why I bring this up. Dr. Wolf-Klein explained that that was not deemed medically effective based on the literature available at the time. And as to ordinary negligence, that would create a tribal issue of fact. But because it's gross negligence, the fact that there was a medical explanation for the choice conclusively demonstrates it was not gross negligence.
And what was the medical explanation?
That the literature available at the time said that I believe that intervention was not effective in preventing falls. That was Dr. Wolf-Klein's testimony.
Thank you.
Thank you.
I think the issue with respect to the interventions relating, I think what Judge Weber was referring to is the chair alarm, that, you know, if a person is seated and it's weighted. So if he gets up, the alarm goes off.
Yeah, the alarm goes off, but he's already on the floor.
Right. So the problem with the defendant's argument on this issue is that there was no assessment that was done. It's the expert that says, oh, you know, these devices would not have been effective, but there's nothing in the record from Hebrew Home that says, hey, we talked about this, we roundtabled this, and we decided that this is something that we should not use.
Well, they progressively did things to increase the level of supervision. It's not as if they saw that he was falling and did absolutely nothing. They tried to increase the level of supervision to the point where they placed him near the nurse's station.
And they still didn't see him fall. And it wasn't just one instance, Judge Mendez. If I'm here and he fell once in a bathroom, or he fell in front of the nurse's station one time.
He was there
I'm
for
not here arguing reckless disregard.
But he was there for 7 years. I think he came in 2005, and then he died in 2012.
Right, but he was not assessed a fall risk until 2 years later. And then, according to Dr. Fox, is when the Depakote was removed in July of 2009 is when the fall started.
But
and
they
it continued for 3
but
years.
my
until
point is that they were doing things to try to prevent him from falling. Gradually, they kept increasing. Let's try this. Let's try this. Let's try this. Until finally they said, let's put him near the nurse's station.
Right.
So it's not as if they simply said, well, forget about him. Just leave him somewhere, and if he falls, he falls.
Respectfully, they did forget about him because even though they had this in their care plan, he was still forgotten about because they still discovered him on the floor with no explanation for what happened. And he couldn't offer. I mean, he could have. I think there were certain instances where he was standing up and trying to pick up the rug and he falls. Well, I mean, if you see that and you know that that's happening, and you know that he stands up and he knows that there's no chair there, then don't let him do these things. If the care plan requires close supervision, don't document the chart to say, I don't know what happened. And if you do that one time, that's negligence. If you do that multiple times over a 3-year period, and the 24 falls was over a 3-year period. I'm not talking about what happened prior to July of 2009. If you look at the records, both experts agree that the falls started in July of 2009 and then concluded 3 years later in July of 2012.
Thank you.
Thank you.
Last but not least, Marshall v. the City of New York. Yes, you may proceed.
Good afternoon, Your Honors. Arthur Schwartz for the appellant, plaintiff. Since I only have 3 minutes, I'm going to try to jump right into what I see as the core issue because the court drawing all inferences in favor of the non-moving party is not supposed to resolve issues of fact unless there's no issue. And it's good to come back to this after not looking at her for a month, but there was testimony on page 176 of the record where I asked the police officer, well, wouldn't it, if you have an order of protection for someone who lives at an address and you live in a different borough and you're in front of that person's house, you have an order of protection against, wouldn't that raise a question in your mind, like what you are doing,
But counsel,
what are you doing there?
Counsel, we can read the record. My question to you is, there was an order of protection. I don't think that's disputed, right? There was a valid order of protection?
Not disputed.
Okay. And in the presence of the police officer, the person for whom the order of protection was against approached the person for whom there was an order of protection in favor of and had a conversation with them, correct?
He saw the police officer standing in front of his house with the guy.
Well, that's a yes. So how or why is that not a violation of the order of protection and therefore give the officer probable cause to arrest the defendant for that violation?
Well, then the question is whether the arrest was for saying, "Where's my $50?" in front of the
The
cop.
order of protection states that you're not to have any contact, annoy, alarm, harass, or communicate with the individual. That's what the order of protection says.
So if that
There was communication by the defendant to the complainant, and also the statements could be seen as a possible threat, right?
no, I don't think could be seen. An
But
officer.
at least the communication is a violation.
Your Honor, I don't think it's a violation. The police officer is standing there. It clearly is an invitation to come over, and walks over, and he looks at the guy and he says, "Where's my $50?" with a police officer standing there. Is that a threat? I don't think that's a threat.
Wilkinson already called 911 and report that the plaintiff had threatened to kill him as soon as the OP expired. So doesn't that provide probable cause?
So Judge, this is where I was trying to get into. So in the testimony, I asked the police officer, wouldn't it raise a question in your mind about what this person was doing there that lives in another borough, standing in front of the house with someone you have an order of protection against. And the police officer said, this is on page 176 of the record, of course, yes. That's what she said. But the judge, in her decision, said, finally, the fact that Wilkinson was returning to the building, his former home, does not on its face constitute materially impeaching circumstances, mandating further inquiry by Officer Jem. Now, the officer said that, the officer, not me, the officer said, yes, of course, that raised an issue for her. The court said it didn't.
Go ahead, sorry.
The court said it didn't.
But at the time, she didn't know that the complainant resided in the Bronx.
No, she said she did know that he resided in the Bronx. That's clear in the record. She knew he resided in the Bronx. She asked him for his identification. She testified several times about her. In fact, that's why I asked her that question, because she admitted that she knew that he lived in the Bronx. So you're setting up a situation where somebody that lives 15 miles away can come in front of somebody's house, stand there, call the police, say I was threatened, and then you know, what if he sets up, like I asked her, what if he sets up a table in front of the house every day, in front of his former residence, to hope that the guy's going to walk over to him?
So
The officer
what's the
said
lack-
it raised questions.
What would be the
Judge said it
lack of probable cause? What's the lack of probable cause? You have the order of protection, states that they're not to have any contact, and then you have communication by the defendant to the complainant.
Because the question is, why was Wilkinson there?
That might be a question in the criminal case, but in this probable cause case, which is towards the police officer, if there's an order of protection and then communication in violation of that order of protection right in front of the police officer, why isn't there probable cause? I understand what you're getting at, and maybe that would be a great defense, but that's not the probable cause part of it, right, at this point.
Well, he never had to defend. The Wilkinson never showed up in court.
Yeah, but the point is, in terms of the police officer and what the police officer is faced with, they're faced with a 911 from the complainant stating that the defendant threatened the complainant. Then when they come on the scene, they're faced with a copy of the order of protection, which is still valid, still in effect, and now communication between the defendant and the complainant, again, coupled with that 911. So why does that not give the police officer probable cause to arrest the defendant for the criminal contempt?
Because the statement was made after the police officer said, "What's going on here?" Was he supposed to not say anything?
He might have been able to respond to the police officer, but to speak directly to the individual would be in violation of the order of protection. I can
But she
appreciate.
hadn't seen.
Is that necessary, that you have to produce the order of protection at that moment? Because I don't think that that's what our case law says, right? Because there are certain situations where there are people who have had crimes committed against them, and they don't have that order of protection in their pocket. So I don't think that that's the case
The
law.
problem is the arrest has consequences. And if there's some doubt in your mind, the arrest had consequences. He spent 8 months in Rikers, and it was dismissed because Mr. Wilkinson never showed up in court. 8 months in Rikers because he couldn't make a $250 bail there. So the officer's actions, the officer is there, doesn't have the
But
order
at
of
the
protection.
time that the officer arrested the defendant, it was based upon probable cause. She did not know that Mr. Wilkinson was not going to show up. She didn't know how the case was going to
But she
progress.
did know that Wilkinson lived in the Bronx, and in her own testimony said, wouldn't that raise a question in your mind? What is he doing here? Did that ever cross your mind? And she said, yes. The judge said it doesn't raise any issue.
It doesn't raise any issue as to probable cause. It raises other issues, perhaps. But you do have time on rebuttal.
Good morning. May it please the court, Hannah Sorokin for the city. Your Honors, the basis for probable cause here is not in dispute. It's not disputed that Mr. Wilkinson made a 911 call, reported that Mr. Marshall had threatened to kill him as soon as the order of protection had expired. It's not disputed that Wilkinson identified himself to the responding officers and also identified Mr. Marshall. So in order to rebut the city's showing of probable cause, appellant would have needed to show materially impeachable circumstances, and he simply didn't do that. The two bases that he argues here are the comment about, where's my $50, which, as Your Honors noticed in this context, can certainly be seen as a threat given that the original assault was over that same $50, and the fact that Mr. Wilkinson was just at that address. And just to clarify, in the arresting officer's deposition, she said that she had the Mr. Wilkinson's ID that listed an address in the Bronx, but she was also at that time aware that he either presently or previously had lived at the address at issue. And there can be any number of reasons that a prior resident would return to a building they once lived in. Friends and family could still live there. In Mr. Marshall's deposition,
I think the bottom line, Counselor, is that, the defense attorneys would always say that the complainant would use it as a sword as opposed to a shield. And I think this shows, this is an example of a complainant who used the order of protection as a sword as opposed to a shield, and had no business coming from the Bronx to that location where he knew the complainant was going to be at. That's the problem for you in terms of the arguments made, but the flip side to that is that there was probable cause based upon that order of protection. But, it smells, and I think there's a reason why it smells. But thank you.
Thank you.
And Your Honor, I want to, so whether there was probable cause is a fact issue, and there were enough questions that it should have been left to a jury to decide, and the judge shouldn't have decided it. And the judge resolved that issue. She resolved the issue. She said it was of no moment that Mr. Wilkinson lived in the Bronx. The officer said it raised a question in her mind. To me, that little kernel is enough, because otherwise you're saying anyone can go hang out in front of a building, even if it doesn't live there anymore, where someone has an order of protection against, and call the police and hope that the guy comes over and says, what's going on? Even saying what's going on would be a violation, theoretically, of the order of protection. Thank you. Sorry for making us